presumption of illegitimacy, and of course Preston Jones and Preston Jones, which decided that 360 days was not a period of gestation which the court should judicially notice was impossible. But on the other hand, the Ontario Court of Appeal, in a case a little later than that, decided 11 years was an impossible period of gestation, and therefore adultery might have taken place. Then we have the also extraordinary Canadian case of Forster and Forster, that's mentioned at the bottom of page 21, in which a judge, not a biased judge in any ordinary sense, but a judge takes judicial notice of the fact, or considers, I should say, the question of whether people have sexual intercourse during menstruation. And you'll see the rather extraordinary remarks of Mr. Justice Schrader, whose cynicism takes over from his judicial notice, in which he decides it possibly can take place because of that black steed passion, as he calls it. On the other hand, Chief Justice Pickup said he was convinced that adultery had not occurred because the idea of sexual intercourse taking place with a woman in her menstrual period is so abhorrent to me. Well, so much for judicial notice. Now, the point I raised 2 or 3 points of evidential interests after that. One is, where is the boundary to be drawn in terms of judicial notice, in terms of these notorious things? Where does judicial notice end, for instance, and the rule in Wright and Tatham take up, is mentioned on page 22. On page 23, where does res ipsa loquitur fit with judicial notice? And that's talked about at some length. And then finally, I think it is finally, questions of historical events. The courts have been most peculiar on the question of historical events. They have taken judicial notice, for instance, that there was an economic depression in the 30s, or that a war was taking place in 1942 in Europe. On the other hand, they would not take judicial notice of the exact date of things like the Battle of Waterloo. I can't understand that at all. This, of course, is the judge doing his 3 monkeys trick. And then on the other hand, as I point out on 24, we have the very extraordinary behavior of the judge in British Columbia taking judicial notice of totally ahistorical material about the communist conspiracy. And then finally, something I think should be talked about in terms of discretionary judicial notice in 19B and C is the question of legislative history as opposed to judicial notice, that the courts are springing more and more and more leaks in terms of looking at Hansard, and I think that's a salutary thing. I'd much rather the judge admit that he's looking at Hansard in the court or in his judgment than to go and sneak away and take peeps at it. And you remember Lord Denning admitted that he often did that. The House of Lords slapped his fingers about that one. But I think that is salutary. The other thing which might suggest that this new document was wise to leave out legislative facts as opposed to adjudicative facts is the slight indication that the notion of Brandeis brief or extra legal social science data is being fed into the court systems. Anti-inflation case was one, Morgenthaler was another. The whole notion of the Brandeis brief, I think, is a very good idea. And I was interested in Mr. Justice G. Arthur Martin's remarks in the Oakes case, that's the reverse onus in narcotics, that in terms of deciding on the question of whether the accused had drugs for the purposes of trafficking, Mr. Justice Martin invited the Crown to put in empirical data in such circumstances. And I think that's very salutary as well. That if we are faced with judges making gross assumptions, often misconceived, about some form of social data which is not accurate and is not clear and is not generally known. I'd much rather see it put in by a Brandeis brief or by looking at the legislative debates than by people acting the way Mr. Justice O'Halloran acted in the infamous Martin against the Law Society of British Columbia. Thanks, Ken.
That was indeed interesting. Marc Gold is the next speaker. He'll be dealing with relevance and discretion to exclude. Marc received his LLB at UBC and his master's in law at Harvard in 1979. He is now teaching at Osgoode Hall Law School at York University, and his major areas of teaching are constitutional law and evidence. Marc?
Thank you, Ken. Just by way of introduction, I want to narrate at least the punchline of a joke. The story is told in various forms. It has an economist and a lawyer and a few other professionals stranded on a desert island with a can of beans, their only food, and no can opener. And the debate ensues as to how they are going to proceed to open the can, with the lawyer not untypically focusing on the process of reaching the appropriate decision, and an engineer drawing tables and imagining angles. The economist, of course, had the most elegant solution. His was simply to assume that they had a can opener, and then it all followed. Well, in a moment, I'll try to tie that into my remarks. The great virtue or the claim of the legislation before us is that it consolidates a rather messy and disparate body of law, making it more clear, more available, and above all, I would think, more predictable and certain, and indeed uniform. And pursuant to this objective, the task force was mandated by the conference to avoid, wherever possible, reliance on a broad judicial discretion. There was a general rejection of the thrust of the Law Reform Code, and indeed that was prudent, I suppose, because that was one of the reasons why the Law Reform Code failed, the degree of discretion. So as a result then, on the surface, we have the Bill S-33 expressed largely as a set of rules which are designed, after all the value trade-offs have been made, to provide a clearer and more predictable and more certain law of evidence. But just as on our desert island, the actual lack of a can opener made the economist's proposal, however elegant, ultimately unreal, so too, I think here, there is a very weak link in the argument that the legislation would, in fact, achieve anything like predictability or certainty or uniformity. And that weak link is the concept of relevance and what that concept entails for the role of counsel, more importantly, the role of the bench. Now, the basic principles governing the admissibility of evidence, the first general set of principles, I should say, are set out in Section 22, by and large capturing the core insight of Thayer that relevance is the central concept in a law of evidence. Only if evidence is relevant will it be admissible. It is, of course, well known that there are many reasons why relevant evidence is excluded. In broad terms, the proposed act, contemplates 4 grounds for exclusion of evidence. The first being where evidence is not relevant. The second, and this, of course, is a decision for which they're not responsible, the drafters are not responsible. The second being where evidence is excluded pursuant to the Charter of Rights, to Section 24 of the Charter, which contemplates an exclusionary rule. The third, where evidence is excluded by some rule of law, a rule either found in the Act, a rule either at common law, or a rule found in some other legislative instrument. The final ground is where the probative force of the evidence is significantly outweighed by its prejudicial impact. Section 22 sub 2 codifies the narrow discretion in the Queen versus Ray. Now, time is running out, if not over, so I will not obviously speak to what was in fact a fairly long paper. I simply want to focus today and share some thoughts about what relevance means and what prejudice means, and why, in my judgment, the attempt to limit the judicial discretion, the attempt to provide for a certain uniformity and predictability, will fail and, if you will, is in the nature of things to fail. And I use an example, which is fact from the reported case. It's from Cloutier versus the Queen, and I may try to simplify it for our purposes. The charge is unlawfully importing marijuana into Canada. The evidence, you might recall, and this is where I fudged the real case, but let's assume that the evidence really does establish that the accused had arranged to import an item of furniture into Canada from some country which produces marijuana, and that furniture was later discovered to have contained large quantities of marijuana. But unfortunately for the Crown, there is no direct evidence that the accused was aware that the furniture contained the drugs, much less intended to import those drugs. So what does the Crown do? It searches, and let's assume legally, the accused's apartment and find marijuana paraphernalia, which we'll assume for the moment, we'll assume that the marijuana they found is not the same marijuana that was found in the furniture, so as to establish that kind of link, a different kind of marijuana. The evidence establishes the accused uses marijuana. Question, is it relevant to his charge of import? The first thing we appreciate when we turn to the Act, Guilt S33, is that there's no definition of relevance. But nothing turns on it, because we all know and we're told that relevance is really just a matter of common sense and experience, that the law furnishes no unique test for relevance. So we turn to other sources, and I offer two. McCormick would have us ask the question, does the existence of this evidence render the desired inference that the accused imported marijuana more probable than that inference would be in the absence of the evidence? An older definition is offered by Stephen, which I think helps to bring to light the crucial fact. So bear with me. He says that the word relevant means that any two facts to which it is applied are so related to each other that according to the common course of events, when either taken by itself or in connection with other facts, proves or renders probable the past, present, or future existence or non-existence of the others. It's a bit of a mouthful, but it clarifies the central aspects I want to bring out. First, relevance is a relational concept. It describes or speaks to the relationship between two propositions of fact, the evidence tendered and the inference desired. And that relationship must be one in which the probability of the desired inference is affected one way or the other by the proposition of fact, which is, after all, the evidence. Second, whether or not evidence really is relevant in any true sense depends upon how the world works, the common course of events. And finally, we appreciate that an item of evidence may be relevant without being sufficient to satisfy whatever the legal standard is. McCormick's oft-cited quip, "A brick is not a wall." Well, that helps us clarify analytically what relevance is all about. We see that the decision not to define it was perfectly appropriate, but is the evidence relevant in the facts I've adapted from Cloutier? Well, the first point to notice is how the judges divided on this question. At trial, it was excluded as irrelevant. Quebec Court of Appeal unanimously held it should have been admitted. Relevant, they thought, both to motive and to mens rea. And a minority of the Supreme Court agreed. I won't read the passages to you. They are set out in the paper. They thought it was relevant essentially because if you use marijuana, you know about marijuana, that would supply the mens rea. If you use marijuana, you want marijuana, that would provide the motive. Mr. Justice Pratt, for the majority of the Supreme Court, disagreed. Again, simply denying those two propositions. Now, if you read Cloutier, you appreciate how conclusory and natural is the tenor of those opinions expressed. We're given no real reason except the assertion by the various courts that it is or is not relevant. And I think that's an important, though often missed point. We reach decisions and judgments about relevance in the most natural, intuitive way, and in this particular case, as in most cases, without the benefit of any empirical evidence. Now, why did the judges disagree? I mean, judges always disagree about things. What were the empirical assumptions that may have caused their disagreement? Well, I had just read a very fascinating book, had nothing to do with evidence, by a political philosopher who used the idea of scripts and dialogues to elucidate what he thought were the foundations of liberalism. It's a wonderful book, but it got me thinking that maybe we could use the idea of scripts and dialogue. So I wrote out a dialogue between two judges to try to get them to join issues on why the evidence was or was not relevant. And it goes something like this. Judge A saying, evidence is clearly relevant to the charge of importing. Judge B, why do you say that? Judge A, because it makes the inference more probable. That's the test to be applied. Sorry. Judge B says, well, that's right, that's the test, but why do you conclude that way? Judge A says, look, it's a question of probability. More drug importers use drugs than do not use drugs. And therefore, it is more likely that if the accused, that the accused being a user imported drugs than it would be had he been a non-user. I don't purport for the moment to defend my claim that in fact makes it relevant or would satisfy any definition of relevance, but I think it will. Judge B then responds, well, how do you know that more that more importers are drug users than not? I have Judge A say somewhat peakishly, don't ask foolish questions, I just know. Now, of course, it's not a foolish question, as I state in my paper, and indeed there are other kinds of questions that would tell us in a scientific way whether it really is relevant. I mean, what's the impact of using a drug on your willingness to break the law? What proportion of traffickers are importers? Is it a business, so to speak, that's carried on by individual users, or is it a somewhat organized enterprise, and all the like? My point, hardly original, certainly confirmed in all the literature, is that the relevance in the true scientific sense depends on these background facts. And these are background facts upon which no evidence is led. And although we can imagine statistical evidence being available and experts, we tend to find, for practical reasons and others perhaps more cynical, that we depend uniquely on the judge's vision of how the world works, on the judge's world view. And so the question then becomes for us not whether drug use is really, truly, scientifically relevant, as the majority denied and the minority affirmed, but whether the judge believes it to be relevant, depending upon his or her experience, his or her vision of the world. Now, that's a commonplace, certainly for practicing bar. It's a commonplace in the literature since the 1930s, but it bears repeating that we are hostage to the judge's unscientific worldview when he or she decides evidence is or is not relevant. And it strikes me, we can call it something other than discretion, and indeed in many ways it's analogous to judicial notice, as Professor Parker talked to you about. It really is part of the same thing. The evidence will go in if the judge has one view, be excluded if the judge has a different view. It is essentially unscientific. Well, so. In the paper, and I won't go through this, I also try to suggest that if it is true that the judge's worldview determines questions of relevancy, so too, I think if we look carefully at the rules as contemplated in the Act, that an incredible measure of judicial discretion is relied upon. An incredible measure. Whether an opinion is admissible depends upon whether it's helpful, says the Supreme Court, says the legislation. That just means, is it relevant? Whether similar fact evidence, we can call it a rule till we're blue in the face. Schweitzer in the Supreme Court says you just balance relevance and probative value and prejudice. In case after case, we find that the key issues boil down to this judge's appreciation of probative value as compared with other competing considerations. And the rules themselves have not managed, and I don't think can manage, to minimize, to any significant extent, that degree of reliance on judicial discretion. Well, the same story in a slightly different key gets played out when judges exercise their discretion to exclude prejudicial evidence. Now, the Queen versus Ray, a much maligned case by some, I suppose, was maligned because it was such a narrow discretion. Of course, now we have the Charter and all kinds of other arguments one could make about unfairness and judicial integrity. But the interesting thing here is how the concept of prejudice itself, to say nothing of the scope of the discretion, once again puts the judge's worldview front and center, and in fact is the determining factor. Cloutier, for example, as a case can be read, or the majority opinion can be read to really be talking about prejudice, not relevance. So what do we mean by prejudice? I think there's two analytically distinct senses in which we use the term, although the literature often lumps them together. One is what one writer has called an estimation problem. If we're not sure how relevant an item of evidence really is, our worry is that the jury will overvalue it, right? That's a common worry that judges talk about. We worry that the jury will think it is much more relevant than we know it really is. An analogous use of the term, the second use, is that we worry that evidence will appeal to some non-rational consideration in the minds of the jury, most often piquing their emotions, their biases, and that we worry that the evidence will be used in a way that doesn't really relate logically to the question of guilt. But the common assumption in both of these is, of course, that the judge who makes that decision knows two things. First, that he knows better than the jury what weight one ought to properly attach to evidence. The judge is the one that knows better than the jury whether it really is relevant. And second, of course, that the judge is able to assess how the jury is likely to use this evidence, or more accurately, misuse this evidence. Now, I think there's something very strange. Herbert Spencer once called the jury 12 persons of average ignorance. Other writers were even less kind. But I think the day has long gone when juries are such idiots that the law at least traditionally thought they were to be. And it's peculiar as well that we ask juries to be there to give us the benefit of their common sense and experience, their own perspective and the layperson's perspective, and yet distrust it ab initio. We don't really want their input because somehow we think we know better. But what is there in legal training, or indeed what is there about sitting on a bench and hearing a series of pathological shoplifting cases week in and week out, that gives to a judge a better sense of relevance than any of us may acquire, or any person, I should say, may acquire in the living of their day-to-day lives? We know that the law gives us no unique test of relevance. We know it's a function of common sense and experience. And we know that judges make unscientific, or essentially unscientific, assumptions which pattern and condition whether or not evidence will be deemed relevant and therefore potentially admissible. So what is prejudice? It's a kind of relevance that the judge doesn't like. Prejudice is simply a label that judges attach to what they imagine a jury will do with evidence, and they worry that the jury will use the evidence in a way objected to by the judge. Now, of course, this is all silly because everybody knows that the Queen versus Ray discretion will never keep any evidence out. And the truth is, in over 50 cases where the Queen versus Ray was cited in the Canadian criminal reports for the point that we're concerned with, not for the confirmation by subsequent fact aspect or similar fact aspect per se, evidence was excluded in 2 cases, 2 out of well over 50. And a casual survey, reveals that the evidence wasn't very weighty that got in. And, although I won't take this up here, if you look at the rest of the law, as you've been doing for the last 2 days, I mean, we have to concede that the concern about prejudicial evidence informs all sorts of other areas of the law. Cross-examination of prior convictions, evidence of similar acts, etc. And lawyers and judges have made over years good faith attempts to strike an appropriate balance. But if you stand back and look at what goes in and how it goes in the context of the absolute inability of the limiting instructions to remove the predisposition of a jury to use the evidence that they hear, as any human would, they believe it or they don't believe it. When you add all that together, an incredible amount of prejudicial evidence goes in all the time. And not because courts aren't exercising their discretion properly, it's because the rules themselves, in their operation in the aggregate, allow in a lot of minimally probative but highly prejudicial evidence. So the irony is that Section 22, sub 2, the re discretion, will keep very little prejudicial evidence out, and the rules will let a great deal in. Now, in the paper, which might be helpful to you in one respect, I go into some detail about exclusion of evidence under the Charter. And so I take up, at least according to the cases as yet decided, some of the procedural and substantive questions. And I really don't want to take up your time with that. But I want to suggest that the same story gets played out here. And indeed, there's no reason to think otherwise. The task force quite properly realized that to include a broad exclusionary discretion was to, in a sense, make each case hostage to the individual judge. And that's what's happening. If evidence is obtained in a manner inconsistent, or rather that violates the Constitution, the Charter, the court can exclude that evidence if its admission would tend to bring the administration of justice into disrepute. As you'd expect, judges have divided as to what that phrase means. And what appears to be the case is that judges are relying on their own sense of what the public will or will not tolerate by way of official actions, police and court actions. No evidence is ever led about what the community standards are, assuming it were available. It is the judge's vision of the world, once again, here, what the public will tolerate, that determines admissibility. My point in all of this is, I suppose by now obvious, that a huge structure of rules, and this of course is true about the law of evidence as it evolved, has been built upon the core concept of relevance. The rules, largely exclusionary, of course, therefore are parasitic upon the degree to which the concept of relevance as applied by the trial judge is something which we can get a handle on and predict with some confidence. My point is therefore, that it is a misconception to think of the law of evidence as a set of rules as it operates, certainly to the extent that that gives us some false sense of comfort about predictability. Judges will rely on their own sense of reliability in the business records or computer records cases. That's why we have no litigation on the business records sections, I suggest. It's not because lawyers aren't hip to the technical arguments they could make, because they know that judges take a look and said, this is hearsay, but it's great hearsay, and we want to hear it, or whatever the issue is. The ostensible certainty entailed by the rules is illusory. The judge applies his or her own vision of the world, how the world operates, in deciding what is relevant. Transpose that a bit, what is prejudicial. Transpose that a bit, what would threaten the integrity of the system. Counsel, I suggest to you, would be much better off focusing on general principles of admissibility in preparation of your case. You pitch it in whatever language you think is appropriate, whatever the judge, the point of view the judge takes. Sure, you find the appropriate language, but don't lose the, I'm terrible with cliches, you don't lose sight of the forest for the trees. In practice, the law at the trial level, the law of evidence is a matter of very mildly constrained discretion, focusing on broad principles. If it's really relevant and probative, 99 times out of 100 you'll get it in, and you know that. And your major focus on arguments about admissibility are not the technical details of the rules at trial. You tend to focus either on, or appeal rather, to the judge's sense of how the world works. Everybody knows, Your Honor, that people that check into hotel rooms with baggage intend to stay overnight, and if they're not married and give false names, we know they're going to sleep together. Or vice versa. You appeal to the judge's sense of justice, which of course cuts both ways. Justice demands that we punish the guilty. Let in all the evidence. It's probative. We don't care how it was obtained. That's our tradition. Sense of justice is all about protecting rights. Give effect to the charter. Keep out prejudicial evidence. These are the real focus points. This is what works, human being to human being in court. Now, I'm, of course, typically, as a tenured academic, allowed to be overbroad and too blunt. And no doubt, and I don't mean to disparage for a moment, the value of the rules as sort of, if you will, establishing the burden of proof and who goes first, so to speak, and who has to convince who in general terms about what. But my question is simply, or I think the danger for the bar, the danger for the law, is to think that somehow by capturing all of the law in a legislative statement, however good, bad, or indifferent it may be as we take different views on this thing, then in a sense we've really accomplished a great deal by way of making the law more predictable, more certain, less a matter of constrained discretion on the part of the court. Which leads, of course, to a question we can pursue today. If any of this is correct and not simply sort of Jerome Frank revisited, which it may very well be, then I think it forces us to stand back and look at the content and substance of Bill S-33 and say, look, is this on the merits really worth the effort? If, as I'm trying to argue, it will not accomplish what it ostensibly sets out to accomplish, then it must be judged on its merits, on its substance, on whether it really is fair to the accused persons or fair to parties to civil litigation. Thank you very much. Mm-hmm.
Eugene?
I'm sorry.
I'd like to know the title of your wonderful book about liberalism. Who wrote it?
Oh, that was Ackerman, Professor Ackerman at Yale. Yeah.
Second point on that is, and I was going to use, I was going to call you the young Jerome Frank, and I think we all tend to be somewhat cynical and skeptical, but I'm a little bit older than you are. In relation to relevance, we toy with the question of the need for definition, the Stephen definition or the law reform definition, evidence having any tendency to reason, proof of fact, and issue. We thought that was so basic. It's a logical concept. It's an analytical concept that we didn't need it. But my point in relation to Kluge is, do you not think that Kluge was really an application of Ray? That is, if you have any tendency to reason, it's admissible, but where there is a prejudicial fact that you're a user of marijuana, it's not an offense in itself, but it's prejudicial in the eyes of the priors of fact, that you've got to get past that hurdle. And Mr. Justice Pratt, before he vacated the Supreme Court of Canada, came up with this substantial relevance test. So it isn't quite as much, say, as the similar fact, there has to be at least probable, but at least that there is some life in Ray, although we all tend to denigrate it. And you can argue that somehow what that evidence is, it's not good enough, it merely has tendency to follow, but it has to have, perhaps get into the 20% projectile or something else like that. And then after that, I simply would say that I tend to agree with you that your world set, your worldview, whatever, the so-called human factor, it's hard to legislate out. Even if you say you must give your reasons, you necessarily have to give all the premises that lead to that conclusion, and I don't think you can really get away from that. Perhaps it's really not related to the need for an evidence code. The American judges that we've talked to, law professors, lawyers, and such, have all told us that, in fact, the federal rules, which came in 76, have been a wonderful experience. That although there was an issue on generating new case law and such, it's settled the areas. There's a predictability is there, the accessibility is there. The appellate cases have been cut down from 60 to 70%, and by and large, all the legal community, including defense counsel, are very satisfied. So I just throw those observations out. Perhaps you can comment if you wish on any of those.
Can I just sum that up, because I don't think any of that's caught by these microphones here. I'll be a little, perhaps a little too brief. I think the first point was that Kluge was just an application of Ray in regard to the relevance question, and secondly, in regard to having a comprehensive statement of the rules of evidence. That is the whole purpose, if there is one for Bill S-33. Eugene cites the American experience of the federal rules of evidence, which came into effect on July the 1st, 1975, and the fact that the American commentators there, by and large, agree that that was the right step, that it has settled a lot of points and made the law much more accessible.
Well, with respect to the first point, I think that's right. I mean, I think that if you had to choose sides, was Pratt just saying it's not relevant at all, or was he saying it's prejudicial? I think the language supports the latter, that he says, look, all it can do is raise suspicion. That's precisely the kind of evidence we can't have. So I quite agree. Your further point was, I suppose, that there's something sensible going on, that you need, relevance is fine, but you usually need a little bit more than just logical relevance, or whatever the term is, to get over the hurdle. I think that's correct. I used the case, though, I still would like to say, though, that when courts, in fact, specifically invoke Ray, in other words, when they say, look, we've got this evidence and it seems to be admissible, what about our discretion? It's at that level that I think we see that either the rules are so clear that the evidence is admissible, in which case Ray on its own terms doesn't apply, or for some reason or other, their judgment about it being prima facie admissible has also, in a sense, informed their decision about how the balance between probative value and prejudice should be struck. I think that's why we don't see it successfully invoked, or successfully in the sense of excluding evidence. But having said that about Cloutier, the interesting thing for me is I mean, I would tend, I suppose, to agree with Justice Pratt. It's not sufficiently relevant. I wasn't trying to put the judges down, but they did disagree. And one can play with the background facts or imagine different worlds where, in fact, one could say with some plausibility that it really was relevant. I mean, for example, if we knew that no person who ever trafficked in drugs was not a user, or put it more positively, that all traffickers were users, and that nobody who didn't use it ever trafficked in it, well, we would certainly have a stronger case for saying it's relevant. And similarly, we could play with the time and culture, et cetera, to find that. So my point is that, though that might perhaps be an easy case for us, in many, many cases, we're simply going to have to accept that judges will differ as to how they see the world, and as a result will differ as to whether the evidence will be admissible. Evidence which we all concede would be quite prejudicial. On your other point about the success, the relative success of the federal rules in the United States, I think that's right. It is in complexion and tone a different kind of package of rules, though, to an extent. Would you not agree? That it leans a little bit more towards more discretion in the trial judge, or recognition that it's more of a matter of principles than rules. I think this will be fine if appellate courts say, as they are saying, it seems at the Supreme Court level, look, trial judge, put your mind to the real guts of the real heart of these issues. Act judiciously, and we won't interfere. I think that's the message from Gratt, in a sense from Vetrovic, certainly from Schweitzer. So it works, but often it works because we don't care as much about the rules as we do about what's underlying the rules.
Thanks, Professor Gold. I think your last remarks are a good introduction to our last speaker, Ed Tollefson, because he is the person in Ottawa who is most responsible for Bill S-33. Ed Tollefson is heading up the evidence project within the Department of Justice, and he was a former colleague of mine when I was working on the evidence project in Justice. Ed taught the law of evidence in Saskatchewan many years ago, and was the author of a well-used case book. He's had more than one position within the Department of Justice, and is particularly useful to us as he is, I think, definitely an expert in the law of evidence, having done a PhD in that area, and having studied under the late Sir Rupert Cross. Perhaps Ed will be able to tell us something of what he thinks will happen to the bill in the near future.
not accustomed to these mics, so I hope that I'm not creating a great howl on your tapes or anything like that. Thank you very much, Ken. I'll try to be as brief as I can and let you get off for lunch within maybe 15 minutes. First of all, I'd like to thank you for inviting me to come here to the lecture series today. It's an honor and indeed a privilege to be involved in continuing legal education series. I'd also like to thank you for organizing this series on the bill on behalf of the department. I don't mean you organized it on behalf of the department, but I'd like to thank you on behalf of the department. I think it gives people in the profession an opportunity to look at the bill, hear comments about it, and I hope that it will also serve to dispel some of the myths that may be created about the bill, in the sense that when you hear the bill discussed and you look at it in its totality, I think you'll find that while there are obviously criticisms of the bill, taken overall, it's not a bad bill at all. And I defy you to identify any piece of legislation or indeed any judgment of any court that is not subject to criticism for having missed something. I think that we live in a world of imperfections, and we just strive to avoid as many of the pitfalls as possible. I think this bill hasn't done too badly, although you and I both agree that there are certain areas that if we were the masters of the bill would have gone a little bit differently. It is, of course, a compromise, because this is not an area where you can achieve absolute consensus. You have to make value judgments that this is better than that sometimes. I've been described in various terms as being the father of the bill, the drafter of the bill. I don't think I can claim credit for either of those. Certainly I've been very intimately involved in it, as Ken was before me, as both the chairman of the member first and then chairman of the task force, and subsequently the person who gave instructions to the draftsman. The credit for the bill, which I think is actually a very well-drafted bill in terms of clarity, must go to Bernie Schaefer, the draftsman of the department. Any criticisms, I think, have to be tempered by the fact that a draftsman can only work within the confines of the policy decisions that were taken for him by other people. He also has to work within the confines of the limitations of language itself. If you don't want to get a legislative provision that is going on and on and on, trying to cover every conceivable possibility, you have to make some choices, and you try to keep the language as simple and as short as possible so that the court can make some sense of it. I would ask the audience whether they'd prefer to have this kind of a bill or the Income Tax Act, for example, as the basic guide for the rules of evidence. Well, he's worked on it for 20 years, I would think, or maybe even longer. But I think that the most people here would say, yes, let's have the short, snappy provisions, the ones that are reasonably clear, that use fairly simple, straightforward language. Maybe there are some questions about the meaning. Well, these things can be worked out. And I think that in comparison with the present Canada Evidence Act, which is riddled with inconsistencies, ambiguities, with words that you just don't know what they mean, Bill S-33 is a considerable improvement. You'll get criticisms. I don't want to take up too much time on this, but I just point out one reference earlier today by Alan Gold when he was dealing with Section 85, I think it was, of the bill in relation to alibi. The bill says quite explicitly exactly what it means. He said, oh yeah, that's right, it's quite clear, but counsel might say it means this. Well, I guess there's no way that the draftsman can avoid counsel putting whatever interpretation he wants to put on to words, however strained, however perverse it may be. You do your best to put it in plain, ordinary English, and if the counsel still want to twist the English to suit the purposes of their own particular client's claim, they'll do so. So that's c'est la vie, I guess is what one would say in Ottawa. On the question of where do we go from here, Ken asked me to comment on what's the projected legislative history of this. You may ask, first of all, why is this a Senate bill? Have we already gone through the House of Commons? The answer is no, we haven't. When we were considering our legislative options, we obviously originally thought that we'd go into the Commons, but the workload in the Commons right now is very heavy, and a decision was taken by the government that they did not want to clutter up their order paper, essentially, with subjects that were not in the economic sphere. They placed that as their highest priority. And in order to get any publicity for the bill at all, get it into the public domain, it was thought wise to introduce it in the Senate. I think, quite frankly, that's a very good decision. Not saying this in any political sense, but my experience with the Senate committee is that they look at the bill that's before them in a much more dispassionate way, perhaps, than does the Commons Committee, because you don't have the partisan atmosphere. And I think so far as public hearings are concerned, I think the Senate will do a very good job indeed in affording an opportunity for individuals and groups to have their say on what the weaknesses and strengths of the bill might be. If at all possible, I imagine that the government would like to see all of the comments and criticisms made before the Senate committee, so that when it does finally get into the Commons Committee on Justice and Legal Affairs, the amount of public hearings, or the number of groups that have to be heard, can be reduced to a minimum. Now, when is it likely to get into the Commons? I gather that there's no possibility really of doing anything before the summer recess. We only have effectively 2 months left, and there's quite a bit to do in the Senate yet on the bill, and certainly the Commons wouldn't have time. So our hope is that we'd be able to get it into the Commons when the Parliament reconvenes in the fall, but that, of course, will have to depend upon the legislative priorities at that particular time. How quickly it can go through the Commons Committee, of course, is a matter which we have no control over. This is a matter that is determined by the political exigencies of that day. So when will this see the light of day as the law of the land? I don't know. I would hope that it doesn't wait too long, because these things get stale, and the decisions that are taken on the basis of the state of the law in 1979 and 80 very quickly can lose their currency. And I suppose that that over a period of time could jeopardize the possibility of the bill ever becoming law. But I am still fairly confident, and certainly the provinces are anxious to see this, because they want to make changes in relation to their own evidence acts. Let me turn very briefly to the questions that were addressed to me as commentator in relation to the area of privilege. I don't plan to go through my entire paper. I'm sure that all of you not only can read, but you're hungry. And therefore, my basic comments are going to be in a very telegraphic form, if not very cryptic. The bill does not deal exhaustively with the area of privilege. Quite often the bill is referred to as a code of evidence, whereas in fact as is pointed out, there are certain areas that have been left for development by the courts through the case law. This is certainly one of those areas. For example, we do not deal with the question of solicitor-client privilege. We don't deal with other statutory privileges. These can be dealt with in the statute that is the subject matter statute. The privileges that are in fact dealt with are in relation to the use of previous testimony, in relation to psychiatric assessment, where we set up a new privilege, in relation to matrimonial communications, and then finally that area that is known generally as Crown privilege. In relation to the use of previous testimony, in my view, if any provision of evidentiary law in Canada ought to be criticized for its inadequacy in terms of draftsmanship, Section 5 of the Canada Evidence Act is that section. It is terrible. And yet, has there been any great outcry, any screams of indignation or outrage about it? It's very strange. I remember once putting a question to a person who's now a very well-respected judge out west as to whether it was necessary for a person to claim the protection of both the Canada Evidence Act and the Provincial Evidence Act. This is the classic way of doing it out west. I don't know what the practice is in Ontario, Eugene. Obviously, it's not necessary. You say that you're objecting on the basis of this particular act that governs that proceeding. I put it this to this individual, and he said, well, you know, Ed, at least it can't do any harm. Well, now I was an academic in those days, and that sort of shook my confidence for a moment in the legal profession and in the judiciary, but nevertheless, I think that as Laskin said in the Horsburgh case about the oath, surely the 20th century deserves better of the common law. I think that the latter quarter of the 20th century deserves better of the Evidence Act. We should be able to be a bit more explicit and spell out the rule more clearly. What we have done in Bill S-33, therefore, is to retain the basic concept of an immunity provision whereby you state, or whereby the law gives you an immunity against further use of your answer, rather than the common law rule whereby you were entitled to object to answering a particular question. Where we've made the change is in the following areas. First of all, because of the Charter, you don't have to make the claim anymore. The Charter, Section 13, says that it is a right of any witness not to have his answers used in a subsequent proceeding. Now, the Charter restricts it to incriminating answers. Bill S-33, based upon the recommendations of the task force and the Uniform Law Conference, applies it to all answers. Now, that may seem like quite a dramatic change, and I think it probably is in terms of what the understanding of the law is at the present day. We think of the Section 5 of the Canada Evidence Act as being the Canadian equivalent of the American Fifth Amendment, I suppose. It's a privilege against self-incrimination. Although, if you look at Section 5.1, you'll see that even that section talks about an answer to a question which may tend not only to criminate him, but may tend to establish his liability to a civil proceeding at the instance of the Crown or of any person. What does a civil proceeding mean? Case law is not clear on that at all. In fact, there's been hardly any case law in Canada. Now, we took the view in the task force that probably it was simplest and wisest to provide protection for all answers Why? Well, for two reasons. One was that this avoided the difficulty of determining later on whether an answer was in fact a incriminating answer, which is by no means clear in some instances. And secondly, as a matter of policy, a witness who is called to testify in a proceeding surely is being called there to assist the court in determining the facts of that case, not to provide a mechanism for disclosure against that particular witness in some subsequent proceeding. Therefore, why should his answers be usable against him in a subsequent proceeding? If you have a civil proceeding against him subsequently, he can be called and he can be asked to testify. Why should you simply be able to read in the answers he gave in a previous proceeding and say, that's our case, my lord? Secondly, I guess the major change comes in relation to documents. Section 5 doesn't refer to documents, and the courts have had some questions as to whether, in fact, it does include documents. At common law, of course, documentary evidence which was incriminating could be excluded. It fell within the common law privilege against self-incrimination. My own view is Section 5 doesn't deal with that. Ergo, the common law protection still exists. The task force recommended that the documentary privilege be continued, but the Uniform Law Conference said no, there is a clear distinction between incrimination by documents and incrimination by oral testimony. A person who is testifying as a witness runs the risk of being charged with perjury. If it's a document that's being tendered, that doesn't apply. Therefore, they said the privilege with respect to incriminating documents should be abolished. I don't think it's going to make that much difference, quite frankly, in terms of actual practice, because frankly, I don't think that the average lawyer makes much use of that, although there have been some cases in the past. Nor does the privilege apply to corporations. There's been some doubt as to the scope of the protection under Section 5 for corporations. The new provision expressly excludes corporations from the protection of the immunity. Our view, once again, was that the intention was to protect real, live witnesses. It was a personal protection. This was the way it had grown up in the common law. This is the way the Americans have always treated it, and that there is no reason to provide protection for corporations. This is spelled out in the Act. Now, there are certain things that should be brought to your attention. It doesn't provide immunity with respect to raising the same question in a subsequent proceeding in the same cause. For example, you claim or if the statement was made in a preliminary inquiry, obviously you can't exclude that statement in the trial. Same in the civil cases where you have a discovery, you wouldn't want to have the statement excluded at the trial on the basis of the immunity provision. It does not provide protection against the use of the statement in a subsequent prosecution for perjury or the giving of contradictory evidence. Here is a change because at the present time the section only has an exception with respect to a prosecution for perjury in the giving of that evidence. And as I point out in the paper, that's a fairly restrictive proposition, because in some instances you'll have the witness saying X did it in one trial, Y did it, he says, in another trial. He's obviously perjured himself in one of them. The prosecution in the perjury case wants to show the inconsistency, but if he has the protection of Section 5, you could bring in, let's assume he was being prosecuted for the first statement. You could bring in evidence that he'd made the statement that X did it, because that would be within Section 5. But you couldn't bring in evidence that he said in the second trial that Y did it. And that didn't seem to us to be much, to make much sense. There had been a move to make this change about 40 years ago. Got into the legislative process and died on the order paper. Well, we're trying to revive that and clarify it. Also, you'll recall that in the case, I think it was it Savillon, where they said that it didn't apply to prosecution for giving of contradictory evidence. The wording was quite explicit, it only applied to perjury. Well, that doesn't make much sense either. So that is part of the exception now. You can use the statement in a prosecution either for perjury or giving of contradictory evidence. The question of whether it can be used in to test credibility is not clear in the present law, and it was felt that particularly in view of the fact that the claim no longer has to be made, so it's impossible to identify those statements that fall within the protection of the, or should fall within the protection of the section. You have to permit any statement to be used for purposes of testing credibility. In other words, if he has made a statement in a previous judicial setting saying X, and in a subsequent one he says Y, there has to be a possibility to test his credibility by putting the previous statement to him. However, the provision says it has to be an inconsistency in a material particular. So this gives the judge some discretion to exclude minor inconsistencies. Well, by and large, I don't think this is going to make a great change in the practice. I think it clarifies a number of things, but will not cause any great problems in terms of the